Hey everyone, thanks for coming. It's 7:01 now, so technically I would start now, but I'm gonna wait a few more minutes to see if anyone comes in. Maybe we'll have some late people.
So what are you planning to cover tonight as opposed to last time?
Similarly to last time, I don't really have much of a direction, I think. I just watched the review session that was posted today. I took notes on that, so there were a few things in there that I would like to hit on, make sure that I have understanding of. Um, Somebody also, a student, I don't remember who it was, but they asked if we could go over some more multiple choice today. So that's also an option for people who don't have the e-text. But yeah, so I'm in your guys' class too. And so really, I wanted to host these sessions because I figured somebody might have a better clue on what to do than myself. But there's lots of stuff we can do. Did you have any ideas, Matthew?
Well, I had to leave the other session, so I don't know what you went over for the next couple hours you held it. But I know that what we went over when I was there was some multiple choice. We also went over some case studies. I'm down to go over more contract law, but if you already did that, I guess I could go watch the other review session.
Yeah, I would
know
definitely.
contract laws. Yeah.
I would definitely watch the review session, recording. I was like just listening to it while I was driving in the car is kind of helpful. Has anyone watched the review video from this morning or actually attended that lecture this morning?
I've seen about half of it.
I was there.
Okay, so it sounds like we have some people yes, some people no, but that's okay. I actually took really detailed notes on what he went over, and in that video, he basically outlines like how to approach essay questions. So yeah, does everyone have the review materials that I shared with the class? Yeah, okay. Great. So we'll just get started right away, hey? Let's see what I've got. So unless somebody has a better idea of what direction we should move in, what I can do is just go over what that review video, what Professor Nolan went over in the review video that he posted today. He basically said everything that he went over is going to be really helpful for essays, but there is a chance that a lot of the stuff on the multiple choice will actually be more from the book rather than what he went over in that video. Okay, so before I begin, does anyone have a better idea, or is just going over that review video real quick kind of a good first move?
I think
that's a good idea.
I wasn't here for the first review you did. Did you record that one as well by any chance? Or
Yes, so the first review session was recorded. I sent it out through Canvas to everyone, and it's also in GroupMe if you have that.
okay.
He sent out an announcement, and it's in like a Google Doc link.
Yeah.
Like Connor sent out the announcement.
Yeah, if you can't find that, just go ahead and message me, and I can shoot you a link, no problem. Okay, so first off, there's just some administrative stuff about the exam. It's going to be 50 multiple choice and 5 essay questions. The essay questions are worth 10 points apiece. The multiple choice questions are worth 1 point apiece. The essay is 2 hours long. You have 2-hour limit. The exam opens at 8 a.m. and it closes at 11 o'clock, I think. So the latest you can start is 9 p.m. It's going to be on Canvas.
And still get the 2 hours, right?
Yeah, and still get your full time limit. It's going to be through Canvas, through Proctorio. Has anyone used Proctorio? Because I have not myself, so I don't really know how that works.
So I've used Proctorio. The things you're going to need is a webcam so they can see the room, and also you're going to need a microphone that's turned on. Most webcams come with those already pre-built in them, because they want to make sure no one is feeding you answers from, behind the curtain or whatever.
Okay. Do we need ID or anything like that?
You will need to show an ID. So you either your student ID or your state ID.
And make sure you install it as like a Google Chrome extension.
Yeah.
Wait, Proctorio?
If you use a Mac, yeah, Proctorio is an extension
on Chrome.
Okay.
I recommend that if you've never used it before, you and if you're going to start your exam later in the day, you start it at least maybe 15-20 minutes before 9 p.m. so you can set up Proctorio and get that all working, because sometimes it's a hassle. It'll also ask you occasionally to scan the room.
So he actually did say that in the lecture, that it's going to make you scan your room. And he
you
said,
want to make sure if you have any smartwatches or anything to take that off too, because I got flagged on one of my last tests for having a smartwatch on. They were like, next time you do this, like, we can fail you. And I'm like, okay.
Smartwatch, okay, well.
If you have like a smartwatch or your phones, like make sure it's not in sight, because you'll get flagged.
Yeah, Nolan also said, like, make sure your desk is clear, because since we're allowed the note sheet, it's gonna flag us. But if there's a bunch of shit on our desk as well as our note sheet, it's probably gonna be cheating. So just be aware of that. Okay, so we have some questions in the chat. Sorry, Matthew, what are you saying?
Oh, I was just gonna say, you don't even cheat, and then you get flagged for cheating, and they give you 0, and you're just like,
yeah. So Crew asked if I can send that PowerPoint. I'm definitely gonna send that. I'll just have to find the link and post it here. And then somebody from their iPhone asks, what topics will most likely be essay questions? So yeah, that's exactly what I was gonna go over now. So for essay questions, we can expect contract law. Okay, contracts.
Yeah.
Or sorry, constitutional law. Admin law. Torts and negligence.
Or criminal law.
Criminal law, product liability. Intellectual property. Criminal law.
We're either going to have torts and negligence or criminal law, not both.
Oh, it's one or the other. That's what he said?
Mm.
Okay.
Yeah.
And contracts. And bankruptcy. Bankruptcy and secured transactions. Okay, so those are in his review video. These are the topics that he went over. He went over them very quickly, but very useful notes. So should I go over each one of these a little more in depth, or?
Yeah, please.
Okay.
Yeah.
I had just uploaded your PowerPoint, by the way. Somebody had asked about it, so it should be in the chat window.
Oh,
is that the updated one that you worked on during the session?
I'm not sure, but I know there is one in the group me somewhere.
Okay, I'm not in the group me, so.
Okay. It's somewhere. I'll find it. Where is it? Yeah, it's above. Yeah, and as soon as I get this link into the chat for you guys, I'll get started on that stuff. So here it is. Copy, paste. There it is. Okay. All right, constitutional law, guys. So constitutional law, he said this is going to be very important. So very important. And so basically, we're going to need to know the Commerce Clause. we need to know the First Amendment, due process, and equal protection. Okay, so yeah, also he said, before he mentioned constitutional law, he said we should know the difference between substantive and procedural law. So right. Administrative law, he says, with administrative law, a lot of students like will get caught up thinking about like details. He said you should think of these like big picture, and any essay questions he asks are going to be talking about like how this how this agency is set up. So how is agency set up? How is agency set up? He'd also like to know what are the powers?
Rulemaking process.
Yeah, so powers of the agency, and then the rulemaking process, and as well as describe how to hold an agency accountable. Describe how to hold accountable. Okay. Agencies are set up with what's called enabling legislation. Okay. The powers of agencies, they have executive, legislative, and judicial. Executive, legislative, and judicial. This is having these powers, they're called semi-tyrannical. Okay. Because they have all three of these powers within each agency. Let's see here. So describe how to hold accountable. So there are information requests. Okay, and that's like stuff like FOIA, Freedom of Information Act. And then there's a political aspect. So in this political aspect, you can get legislation passed to change the agency's mandate or funding. And also there's a third way that you can hold agencies accountable, and you can take them to court to argue constitutionality.
In order to take him to court, though, you have to exhaust all administrative remedies first.
Okay. So after first exhausting all, what did you say, administrative remedies?
Yeah.
Okay. So that's agencies very, very briefly. He did, he mentioned you would also need to know about the rulemaking process, but he didn't talk about that at all. He just said you'll need to know about it and then didn't describe it.
I have that in my notes. Give me 1 second. All right. So there's 7 steps to it.
Okay.
The first one is advance notice of proposal rulemaking. And so that's you're letting people know.
Proposal rulemaking?
Yeah.
Okay.
And then proposed rule.
Yeah.
And then public comment. And then 4 is final rule, and after the finalized agency publishes in the Code of Federal Regulations.
So final rule and then publish.
No, that's for the final rule, it's after finalized agency publishes in the Code of Federal Regulations. After finalized agency publishes in the Code of Federal Regulations. And then 5 is judicial review. 6 is effective date. And 7 is hybrid rulemaking.
Great. So that's basically agencies. Torts and negligence. Moving on to torts and negligence. So the first step to torts and negligence is you're going to define all intentional torts. He said you should have this on your note sheet. He said you're going to basically need to know the definition of all of the intentional torts.
And that one's assault, battery, and false imprisonment.
Are there only 3 intentional torts?
Yeah.
Okay. I'm not too sure about that because I think like arson is that I don't know. I'm gonna trust you. I'll trust. You probably know better than me. I'm not gonna lie. Okay, assault, battery, and what did he say?
False imprisonment.
Okay.
That's what I had in my notes, because then he elaborated on it a little bit, like what exactly assault is, what exactly battery, and then, but I do remember something about arson though.
But isn't the kind of torts like intentional, negligent, and then strict liability? Or did we already cover that?
Yeah, so those are types of torts. We covered that in the previous class, but or the previous review session. But yeah, there are intentional torts.
Oh, so I think she's talking about like intentional torts.
Yeah, so there's like a ton of intentional torts, I'm pretty sure, like different types.
There are.
Like,
yeah, there's lots of
There's
them.
like the emotional one, and
there are a lot of them, and you'll just have to look in your book and find the definitions of each tort. And that's going to be in the chapter on torts, I would assume. So
Yeah, chapter 7.
It's actually under chapter 6, criminal law.
No, that's going to be criminal law.
Yeah, so types
Not
of
tort.
criminal law,
They're
then
different.
you have offenses against person, homicide, assault, and battery. So it just goes through
Yeah,
all the
that's
They go
criminal law. Torts and
together.
criminal law are, they're
you kind of
different.
have to know when to differentiate them, he said, even though they're very similar.
Yeah.
We'll
so
be told if
just
it's
trying
like
to
a
find
criminal
the
law
difference.
question or if it's a torts question.
okay.
Either way.
So it's going to be somewhere in here. I'm not going to look for it right now, but so you're going to define intentional torts on your notes sheet. That's going to be really helpful to answer the essay questions. And then you're also going to need to know the defenses applicable to each tort. So to each intentional tort. So for example, you'll need to know like assault is a intentional tort, and you'll need to know some defense for assault, I guess. I don't know what they are, but I'll figure it out by tomorrow. Self-defense, there you go. Damn, easy one. Are you gonna be a lawyer or what?
No, I took this class at a JC twice.
So there's torts, and then I'm gonna go over negligence. So negligence. So there are 4 elements to negligence. There's duty, breach, injury, and causation. Okay. So when you're arguing for a negligence essay question, you're gonna basically make an argument for each of these duty, breach, injury, causation, and then you're gonna see after that, you're going to see, are there any defenses available? Okay, so say you're suing McDonald's for negligence, you need to show that McDonald's has, failed to uphold some duty that they have to their customers. They're in breach of that duty, which has caused injury or led to injury that they caused. Okay, and then you need to list, like, are there any defenses available for the person getting sued? All right, so on to product liability. So product liability, the first thing you need to know is on a strict. So you need to know what strict product liability is. Okay. And as well as that, on any essay question, it's going to be a 50-50 setup. So the 50-50 setup is going to be, you're going to argue on behalf of the plaintiff, and the defendant. And when you're arguing on the behalf of the plaintiff, you need to first argue that the product was defective. Okay. And to argue that a product is defective, it could have some sort of manufacturing defect. It could have a warning defect, or it could have a design defect. And then, so you'll argue on behalf of the plaintiff that the product was defective, and then you have to argue the defenses. The manufacturer may claim. Okay, so any defenses that the manufacturer may claim, and within that, there's like product misuse. Misuse. Sorry, it's the end of the day, I can't type. Assumption of risk. And there's also comparative negligence or commonly known dangers. So on to intellectual property. There are 3 types of intellectual property that we covered. There's copyright, there's patent, and there's trademark. So copyright is granted upon creation, and patent. Let's see here. Patent. You have to get a patent, you have to file with U.S. Trademark Office. Same with trademark. You also have to file with U.S. Trademark Office. Okay, so he said you need to know how to get each one of these intellectual properties, and you need to know what infringement looks like. So what does infringement look like? And you need to know that for all of these. Okay, so that's intellectual property. Oh, there's one more thing on intellectual property that you have to look out for, and that's what's called the fair use doctrine.
It's not for copyrights only.
Yeah, it's probably for copyrights only. So fair use. Okay. So now on to criminal law. So you need to first, in a essay question for criminal law, you need to outline what is the criminal liability for the problem and person. And criminal liability is the concurrence. So criminal liability is the concurrence between a guilty mind and a criminal act. Okay, so that's what he said. I don't really know exactly what that means, but he said it in the review. It's a concurrence between a guilty mind and a criminal act, Let's see, so continuing with that, you have to, after you outline what the criminal liability for the problem in person is, you're going to just go through the fact pattern and spot like felonies and misdemeanors. So you need to know how to classify felonies and misdemeanors. You'll just go through the fact pattern and say, this is a felony, that's a misdemeanor, that's a felony, that's a felony, that's a misdemeanor, okay? After you do that, you're going to classify each type of crime. Like whether that's a violent crime, whether that's a property crime, there's property crime, public order crimes, white collar crimes, okay? And white collar. Okay, so after you classify each type of crime, you need to mention any applicable defenses. Mention any applicable defenses. And he said it doesn't matter how good the defense is. If it's just like a potential defense, you need to put it down, even if it's not a strong defense. Okay, so that's criminal law. Going on to contracts. Going on to contracts, there are 4 elements. Valid contract. So when you're doing an essay question, you need to identify these 4 elements are being upheld. If they're not being upheld, it's not a valid contract. Okay, so element 1 is agreement. And what agreement is, it's offer plus acceptance. Okay. After agreement, there's the consideration. Then there's capacity. And after capacity, legality. So you have to argue that the contract had an agreement, there was offer and acceptance, clear offer and acceptance, and with offer and acceptance, there's commonly what's called, like, I think it's called the mirror rule, which is like the offer, the acceptance must mirror the offer or something like that. Okay, you might want to look more about that in the book, but there's the mirror rule with offer and acceptance. So then with contracts, after you identify that the 4 elements of a valid contract are either upheld or not, you need to state any defenses against the contract. Okay. Defenses against the contract can include gift. Okay, there's the defense that it's a gift. And I think he said something like promissory estoppel. I don't know what that is. I don't even know if I heard him right when he said that, but something like that. And then there's, you have to see if the statute of frauds applies. So statute of frauds applies.
I think promissory estoppel is like the gift situation, but they're like forced the gift and it's kind of like a contract situation.
Thank you. Okay. So then you check if the statute of frauds applies, and that's it. That's basically what he went over for contracts. Bankruptcy and secured transactions, you need to know how to set up a security interest. Okay. And you need to know the difference between unsecured and secured credit. So secured and unsecured credit. Okay. And then you need to make an argument for which chapter of bankruptcy, you need to make an argument for which chapter of bankruptcy applies. Okay, and so which chapters of bankruptcy are there? There's chapter 7, there's chapter 11, come on, make me spell. Chapter 7, there's chapter 11, and there's chapter 13, bankruptcy. It's really late for me, I'm sorry guys. So chapter 7 has been, so he said it has been made more difficult since 2005. And that's because chapter 7, you are able to liquidate all debts. Okay. Whereas chapter 11 and chapter 13, you're still partially liable for your debts and you'll have to pay something. And yep. And so that's basically everything he went over for essay questions during the review. He said, you're going to want basically to understand all of this and have it for your review sheet. But he said you're going to have to add a lot of stuff from the textbook for the multiple choice, because he said the multiple choice will cover all topics. All topics in the book are available on the multiple choice. And so not just the stuff he covered in lecture will be on multiple choice. It'll be like more broad than that. Okay, so yeah, that's basically his review video summarized really quickly. I'll send this out to you guys. But do we have any questions here, or should we just go over each one of these a little bit further? Okay, so one thing we did in the last study session is we kind of we went over the tort example. We went over mainly essay questions, but we did do a little multiple choice last time. Oh, promissory stuff. Okay, we got some stuff in the chat. So I'm just going to catch up with the chat real quick, guys. Okay, so basically promissory estoppel has to do with the person being reliant on the anticipation of the gift. That way the court won't make them revoke the gift. Give someone $1 million, they start buying houses and made life-changing decisions. Person wants the money back, the court would say it's not fair and won't revoke the gift. Okay, so promissory estoppel is because you promised me some money, I changed my life, and now you can't take it back because it would make me worse off.
I think instead of a gift, it's just a promise, not necessarily a gift. So like, it doesn't have to be like, I gave you a car, you made some life-changing decision because of it. It doesn't have to be a gift. It just has to be like, I'm going to give you, or I'm going to do X, and then you make a life-changing decision because of that. So it's not necessarily a gift. It's just a promise.
Okay. So I'm just going to add that here real quick. So okay, great. So somebody, I don't know if they're actually present here today, but somebody asked me if we could go over some multiple choice. If you guys might find that helpful, we could do that, but unless there's a desire for it, I will not go over multiple choice. Okay, Gabriel. So Gabriel wants to do multiple choice. I'll launch a poll. So maybe I'll launch a poll, I don't know. Okay, so I just launched a quick poll to see if you guys want to do multiple choice. Looks like of everyone who's responded so far, it looks like overwhelmingly we want to do multiple choice. The other option, as opposed to multiple choice, is to go in to further detail on each of these essay, highlighted essay portions. So yeah, looks like 20 out of 21 so far want multiple choice. So that's what we'll do. Okay, so I'll share my screen. I think let's start with constitutional law and work our way from there, just off of this outline that we've done. Okay, so constitutional law. Okay, let's see here. So 4.2, quiz question 1, it says, if Congress is not authorized in the Constitution to make certain laws, then acts unconstitutionally and its actions may be ruled unconstitutional by the Supreme Court. True or false? So let's see if I can put a poll up. I don't know how to use Zoom. True or false? Somebody shout it out.
True.
Okay. Eric says true. Does anyone disagree? That's true. The Constitution is supreme law of the land. It authorizes Congress to make laws. Let's see here. Most of the federally created legal environment springs from this one clause. If the Congress is not authorized in the Constitution to make certain laws, then it acts unconstitutionally and its actions may be ruled unconstitutional by the Supreme Court. Cool. Question 2 says the Supreme Court held that Congress lacked the authority to enact a statute under the Commerce Clause because the statute regulated an activity that substantially affected interstate commerce. True or false?
Pretty sure that's false.
Okay, Matthew says false. We'll see. So the Supreme Court held that Congress lacked the authority to enact a statute under the Commerce Clause because the statute regulated an activity that substantially affected interstate commerce. Yeah, so if something substantially affects interstate commerce, then they would have the authority, right? Okay. This says they would lack the authority. That's false.
They're trying to trick you with that one. If they said like intrastate or something instead of interstate, then it would be different.
Yeah, so yeah, tricky lawyers. Okay, so question 3 says the Compassionate Use Act, a law passed in California, conflicted with the federal, and then our choices are controlled substances, federal analog, chemical diversion and trafficking, fair sentencing, or domestic chemical diversion and control act.
I have no clue.
I'm gonna guess Controlled Substances Act because it has to do with Compassionate Use Act. So I mean, I'm gonna guess drugs, but I have no idea.
Okay, we've got a guess for question 1. Do we have any other responses? Go ahead and type in the chat 1, 2, 3, 4, or 5. Okay, we have controlled substances agrees in agreement. Okay, controlled substance once, controlled substance twice. Any objections? No, controlled substance. Good guess. All right, and here's the justification. In 1996, California voters passed the Compassionate Use Act, legalizing marijuana for medical use. California's law conflicted with the Federal Controlled Substance Act, which banned possession of marijuana. Okay, in 1996, California voters passed the blank, legalizing marijuana. Okay, they just told us the answer. So if you weren't paying attention, it's time to start. Okay, that's the quiz for 4.2. So we'll go on to 4.3. Okay, dormant commerce clause. What's the definition? Somebody. Oh wait, this is the quiz, right? Here we go. Which of the following is true of the dormant commerce clause? So, number one, it gives states complete autonomy in regulating activities within their borders. It voids federal law or whatever parts of it are inconsistent with state law. It gives the Supreme Court the power to determine when state action is excessive. It limits the power of the judiciary relative to that of the states. It gives the states and the federal government equal power over interstate commerce. So Rick Schaefer says D. It limits the power of the judiciary relative to that of the states. The dormant commerce clause limits power of judiciary relative to that of the states. Is anyone in agreement? Does anyone disagree?
I agree with that.
Okay. It's C. It gives the Supreme Court the power to determine when state action is excessive. So that's the dormant commerce clause. I'm going to write that down. Dormant commerce clause, it gives the Supreme Court power to determine when state action is excessive. Okay. Let's go on to, oh, there's only one for this. Okay. 4.4. If a state creates a law that sets standards that conflict with the federal law, the doctrine of preemption will void the state law or whatever parts of it are inconsistent with federal law. True or false? The doctrine of preemption. So what is the doctrine of preemption? The doctrine of preemption says that federal laws trump state laws. And so this says, if a state creates a law that is in conflict with the federal law, the doctrine of preemption will void the state law or whatever parts are inconsistent. That's true. Okay. The blank holds that state and federal laws that conflict must yield to the superior law, which is federal law.
True. Oh, whoops.
A, B, C, or D? E. A, B, C, D, or E. Here is going to be E.
It's E.
Yeah,
Yeah.
it's based off of the previous question. The preemption doctrine derives from the blank clause of the Constitution: commerce, takings, exculpatory, supremacy, or merger clause.
I'm going to say supremacy.
Big time. Supremacy clause. The supremacy clause basically states the federal law or Constitution is law of land. Okay. Great job, guys. We're doing good. We're doing really good. Okay, 4.5 quiz. The guarantees of the Bill of Rights can limit what a person in the private sector may do. True or false?
I think it's false because this is like tricky. This is like worded trickily, you know?
Yes, it's false.
Because I don't think it's only the private sector.
The Bill of Rights gives you extends rights from the government to the citizen, not from private sector to citizen, right? The guarantees of the Bill of Rights apply only to state and federal government action. Okay. Blank has been given the highest level of protection over such other forms of speech: commercial speech, slander, libel, obscene speech, political speech. Which one has the highest level of protection?
Political speech.
Political speech, right? Libel is not protected speech. Slander is not protected speech. Obscene speech can be protected speech, but it also can be like obscene speech is not protected. I'm sorry. Submit. So political speech is given the highest level of protection. Which of the following amendments to the Constitution protects the freedom of speech and press? 1st, 4th, 14th, 5th, or 19th?
First.
Yep, freedom of speech and press is the First Amendment. That also gives freedom of religion and congregation. Okay, which of the following amendments says all persons shall be secured in their persons, houses, papers, and effects from unreasonable searches and seizures, and no warrants shall issue but upon probable cause before a magistrate and upon oath, specifically describing the persons to be searched and places to be seized? 4th, 14th, 1st, 2nd, 5th.
I think this is the Fourth Amendment, right?
It is.
I think so too. Yeah.
100%. Search and seizure, unreasonable search and seizure, Fourth Amendment. Okay. In terms of the blank, the Fifth Amendment prevents government from arbitrarily taking the life of a criminal defendant. Takings clause, procedural due process, enumerated due process right, confrontation clause, supremacy clause.
This
I think it's procedural due process.
Yeah, I was gonna say the
Yeah.
same.
I agree. I
What
agree
that
with
has
that.
to do with
Okay.
Ooh,
The
okay.
Fifth Amendment has three principal aspects: procedural due process, the takings clause, and substantive due process. In terms of procedural due process, the amendment prevents government from arbitrarily taking the life. So the blank of the Fifth Amendment ensures that the government does not take private property without the just compensation.
the takings clause.
Taking clause. Yeah, that makes the most sense.
Seems the most obvious, right? Okay, taking clause, you're correct. Okay, which of the following amendments requires that states treat citizens of other states with due process? 14th,
believe
2nd,
that's the
1st, 5th, 4th.
14th.
14th. Yep.
Okay, the 14th Amendment requires that states treat citizens of other states with due process. This can be either an issue of procedural due process or an issue of substantive due process. Okay, which of the following falls under the classification of intermediate scrutiny? Scrutiny permissible under 14th Amendment. Under classification of intermediate scrutiny.
I think gender.
Yeah,
Gender.
I agree.
Great. So which of the following falls under the classification of minimal scrutiny?
C.
Economic relations.
Yeah.
Great. Which of the following falls under the classification of strict scrutiny?
Ethnicity.
Yeah.
Okay. 4-6. Quiz. No quiz. Okay, so that's Constitution. Now to administrative law. Okay. Federal administrative agencies can make rules that have the same binding effect as statutes by Congress. True or false? True.
True.
Yeah,
True.
they can make rules. Yeah. Blank are governmental units, either state or federal, that have specialized expertise and authority over some area of the economy. These are,
Administrative agencies.
yeah, perfect.
Yeah.
Thanks, Rick. The first federal agency in the United States created in 1887 was the
Interstate Commerce Commission
good job.
and the Federal Trade Commission.
Congress gives powers to an agency through legislation known as
Enabling Act.
an enabling act. Great. Cool. 5-2. Okay, Congress cannot pass a law repealing a regulation that an agency promulgates.
False.
Yeah, that's actually one of the only ways to hold an agency accountable.
Mhm.
Okay, so 5-3. The blank is the federal act that governs all agency procedures in both hearings and rulemaking. Regulatory flexibility.
The
Did you say-
Administrative Procedure Act.
Okay,
Yeah.
Administrative Procedure Act. Great. A blank, the primary hearing officer in an administrative agency, provides the initial ruling of the agency, often called an order in any contested proceeding.
Administrative law judge.
Blank directs agencies about to engage in rulemaking to give notice in the Federal Register of their intent to do so.
Administrative Procedure Act.
The blank is where all proposed administrative regulations are published daily, usually inviting comment from interested parties in the process of informal rulemaking.
The Federal Register.
Administrative regulations are not legally binding unless they are published.
True.
I don't know.
50-50, true. Okay, the blank, a compilation of all final agency rules, has the same legal effect as a bill passed by Congress and signed into law by the president.
Code of Federal Regulations.
Great. Okay. 5-4. Under the Paperwork Reduction Act, the blank has the power to develop uniform policies for coordinating the gathering, storage, and transmission of all the millions of reports flowing in each year to the scores of federal departments and agencies requesting information. What has the power to develop uniform policies for coordinating the transmission of the reports?
I think
The
opposite.
Office of Management and Budget. Sorry.
Which of the following is true in inspections of forced places? I think it's C. That's my guess.
I think it's A.
I think
A.
it's A. Because that's like the one thing I wrote down. The no warrant is required.
All right.
Perfect. Okay. Where a certain type of business is closely regulated, surprise inspections are the norm and no warrant is required. Great. It is not possible for inspections to take place without a search warrant and without permission of business. We just went over that. Okay, which of the following types of information can be obtained under the Freedom of Information Act?
I think B.
I think it's C.
No, it's more than that.
I'm gonna say C.
Yeah, but
Well, I mean, you can request like you can.
I think
request
it's E.
So
I'm gonna do a poll, guys. We'll see. Because we don't seem in agreement on this one. If I could figure out how to do this, damn. Okay.
I think it's B.
Everybody, we're all over the place.
I don't even know how to do this.
All the above.
Yeah, that's the answer we need, all the above.
Yeah, I don't know how to do the polls. Okay,
We'll go with it.
it's B.
Oh.
Wait, who said B? Because somebody said B.
I
Rick
did.
said B. Okay.
I
Information.
don't even remember.
Information
Yeah, I was
about
thinking it. I
regulated
didn't
companies.
say it. But there's the
It's
Freedom of
A.
Information Act, and it opens up government files to the citizens, and then it says any person has a legally enforceable right of all government documents with 9 specific exceptions like trade secrets and stuff like that.
All right. Cool. Next question. In 1966, the U.S. Congress enacted the blank, which gave all persons a legally enforceable right to access to all, oh, really? Freedom of Information Act. Thanks, Kaylee.
You're welcome.
Okay, 5-5.
I wonder
Person
if
is
his
required.
questions are going to be like. Never mind.
I hope they're similar. That'd be sick.
I
Well,
hope
no,
he doesn't
I
word
mean,
them
like,
like super
if they're-
weird.
If they're going to be like, in 1966, this was enacted, like something that specific.
I don't even know what to expect, bro. I'm low key nervous.
For
I got, like-
agencies, you do need to know like how they were set up or something like that. I'm pretty sure.
Yeah.
I have a feeling with how lazy he has been, he's going to grab questions exactly like these for the multiple choice stuff. It's only the essay stuff that he's going to get real detailed on.
God, I hope so. Let's pray.
That's-
Huh?
That's a good point.
Yeah, that is a really good point.
I don't see how it's going to take him 3 weeks to grade essay questions. He literally doesn't have to do anything.
Well, because it's gonna flag every time somebody like looks at their paper for cheating. So he
So he
also,
has to go
other
watch
than
it.
grading, he has to go watch everyone's videos to make sure they weren't cheating. Yeah.
And then he
sounds like
says
a
he
waste
reads
of
everyone's
time.
essays like at least twice, if not 3 times,
He loves his job, man.
before he puts a grade.
I doubt that he loves his job, but
He just really likes law.
my guy hasn't responded back to an email in like 2 weeks, so I just kind of chalked it. I was like, okay, whatever.
Really?
Yeah, I'm just gonna leave it at that.
All right. So does anyone have an answer to this question? A person is required to fulfill the exhaustion of administrative remedies requirement if what? Required to fulfill the exhaustion of administrative remedies requirement.
I think it's A.
Yeah, A.
I want to say it's the final action one. Where was that? I just saw it.
No.
Yeah, but that's if it was
Yes.
just unfavorable to him. That's not
Okay.
saying like it just didn't work out in his favor, I think.
It's okay. To get to court, the appellant must have standing, that is, be in some sense directly affected by the decision or regulation. The case must be ripe for review. Administrative remedies, such as further appeal within the agency, must have been exhausted. So he has standing with respect to the regulation in question. Does anyone know what they mean by he has standing?
Yeah. So what they mean is, if you're, oh, sorry, I was gonna say,
go ahead.
if you're a farmer, right, and the FDA is gonna put some new not the FDA, but whatever rulemaking organization is responsible for that, and you don't like the new regulation because it affects your farming, you have standing in that regard.
Okay.
I think the book also used the terms as like if you can't sue on like your neighbor's behalf. So I think the book used like if you liked looking at your neighbor's flowers and somebody came over and like ran them over and your neighbor doesn't want to replant those flowers, you can't sue on the neighbor's behalf. Like you have to have some like involvement with it. So I think that's kind of where they're coming from.
So basically this sentence must be in some sense directly affected by, okay. I think I get it. Blank is a requirement that anyone wishing to appeal an agency action must wait until the agency has taken final action.
Oh, isn't it the exhaustion of administrative remedies?
Yeah, I think so.
I think it is, yeah.
Yeah. In a previous question, it kind of told us that. An exception to the exhaustion of administrative remedies requirement is if the agency had no authority to issue the rule or regulation in the first place. I think that's true. It sounds true.
Yeah, it is true.
If an appellant claims that an agency's action was ultra virus, he means that.
Oh, beyond the scope of its authority as set down in the statute? That's what I wrote down.
Is that what ultra virus is?
Yeah.
Yeah.
Okay. I trust. Yep. Beyond the scope of its authority as set down in the statute. Great. 5, 6 cases. We don't have quiz on cases, do we? No. Okay. So that's admin law. Now to torts and
I think that he's gonna pull like specific cases that we went over. Like, is he gonna pull like you have to know exactly?
I don't think so. He said we don't need to write down case names or anything like in our essays, but it's good to read to like understand better.
I just didn't know if he was gonna be like, what year did this happen? Like, because that's gonna be.
No, yeah, I asked him. You don't need that.
No, he said it was like it can help like when you're doing like essay questions and stuff, but you really don't need it.
Okay, cool.
Mm-hmm.
Like the examples we went over in class, like those can help.
Are we skipping criminal law?
Criminal law is going to come at the end just because that's the order it is in my outline.
Oh, okay. Sure.
Yeah. So torts. Okay, intentional torts result from carelessness.
No, false.
Well,
I feel like it's true. Oh. My notes are
Okay.
wrong.
There are three kinds of torts: intentional, negligent, and strict liability. Intentional torts arise from intentional acts, whereas unintentional torts often result from carelessness.
Oh, that's what I
I
was
was gonna say,
reading.
it's like
The
a trick
second line of
question.
my note.
Because it's like it says intentional torts result from carelessness, but if it's intentional and it's not careless, it was like
Yeah.
add thought into it.
If this was a you, it would be true. Okay. A tortfeasor is
A.
a person or a legal entity that commits a tort. True. Okay. Strict liability is liability without fault.
Yes.
Blue.
Blank is a defense to a plaintiff's action in tort where the plaintiff has knowingly and voluntarily entered into a risky activity that results in injury.
An assumption of risk.
Assumption of risk, yeah.
Big time. Okay. Question 5. Blank damages are an award of money damages to make the plaintiff whole. It's punitive.
Compensatory.
No.
Oh, is it compensatory?
Yeah.
Yeah, because punitive are like they're trying to prove a point with this.
Yeah, they're
Like
punished.
those really go like above and beyond.
Oh, punitive
they're
damages are
above
like,
and over.
is that like getting sentenced to jail or something?
It can be, but it can also be in the form of money, but it would just be like a huge.
Did he say those are?
It says it's intended to punish the wrongdoer and then deter others from
they're
doing a
not common.
similar conduct
Yeah,
for
he said they're rare.
punitive or whatever.
Okay. Blank damages are awarded in cases where the conduct of the defendant is deemed to be so outrageous that the justice is only served by adding a penalty. This is what we were just talking about, right?
Yeah.
By adding a penalty over and above compensatory damages. Okay. Intentional torts result from, oh, wait. Yeah. So 7 to. Public disclosure of embarrassing facts, for example, the publication of a private citizen's medical records without consent constitutes
Invasion of privacy.
Yeah.
While a patient lay unconscious during a heart surgery, his surgeon removed a small piece of skin from the patient's heel to keep as a souvenir. In this case, the patient can sue the doctor for
Is that negligence?
Battery.
Or is it battery?
unwanted touching.
Yeah.
Oh yeah, okay.
I think it is battery.
In order to get back at Doug for practicing the drums in the basement of his house every morning, Ursula filed a complaint against Doug, claiming that he had stolen her lawnmower. Criminal proceedings were initiated against Doug, and the suit was settled in his favor when it was found by the court that Ursula had never owned a lawnmower. A majority of U.S. courts will allow Doug to file a suit against Ursula for...
Wouldn't that be negligence?
Yeah, negligence is the only one that even makes sense.
I don't know. I feel like it's not
Can somebody-
negligence because that has to do with like.
Can somebody who said negligence
Explain it.
like defend that answer?
I'm just looking at the other ones, and that's the only one that should makes sense.
Okay,
Definitely not burglary. It's definitely not battery. It's definitely not
the
embezzlement.
other
It
one
has to
could
do
be-
with money. So it'd be
But
either
is it just like process of elimination then?
so it's
That's what I
either
think.
negligence or
Okay.
embezzlement, right?
The definition
Yeah, I
of
was stuck
negligence
between those two.
is failure to use reasonable care resulting in damage or injury to another. So like the way I would see that is like she didn't have like the potential damages that he would face in mind.
Yeah,
What's
that makes sense.
what's embezzlement?
Taking money. It's like stealing money.
Like
Mhm.
companies embezzle money.
Does it have
Like
to
if
be
you're, like,
money?
steal- Yeah, like it's like if you like have.
Yeah.
I thought it's just taking property that you're in the possession of.
Every embezzlement case I've ever seen deals with money. So I mean, maybe that, I don't know.
No, embezzlement's like taking money from your company.
Okay, so we'll say negligence. Is that where we're going with?
That's what I think.
Yeah.
Yeah, because I would agree it's definitely not burglary, trespass, or battery. I wouldn't think. It's negligence. Perfect. Malicious prosecution is the tort of causing someone to be prosecuted for a criminal act, knowing that there was no probable cause to believe that the
Yeah, so
plaintiff
like she wasn't thinking of the long-term effects or the effect.
If a defamatory statement is published in written form, it is called larceny, perjury, libel, slander, or extortion.
That's slander.
Libel.
Libel.
Libel. Slander is spoken.
It's
So-
spoken and libel's written.
Yeah. If the harm is done through spoken word, it's slander. Okay. Which of the following is true about defamation? Corporations cannot be defamed. The exercise of due care is an absolute defense to a charge of libel. Any person, living or dead, is capable of being defamed. Libel can be justified by showing that you were quoting someone else.
It's got to be
state-
C, right?
A statement is not
Yeah.
defamatory.
But dead people can't be defamed.
Dead people cannot be defamed. So this
Yeah.
is false.
Okay.
I think it's
the last
D.
one. No,
No,
think
you're
it is
right.
the
You're right.
last
It's the
one.
last
Yeah,
one for
okay,
sure.
it is the last one. I think that's stupid that like a dead person can't be defamed though. Like, I mean, you still have like a reputation once you're dead.
True.
Okay. A statement must be false to be defamatory. Truth is an absolute defense to a charge of libel or slander. So if you called me ugly and bald, you're not slandering me at all because I'm bald. Okay.
I think technically. Never mind. That's stupid.
Yeah, I know. You can't call me ugly because that's not true, man. Okay. The law of defamation is largely built.
He didn't want.
The law
He's
of
not-
defamation is largely built on strict liability.
I think
this
it's
is true.
true.
I've read that somewhere.
Hmm.
Okay, absolute privileges exist for private citizens.
No, false.
I feel like that's not true.
I don't think we have absolute privilege.
That sounds too like king and queen status.
Absolute privileges pertain to those in the public sector. Narrower privileges exist for private citizens. Okay.
Oh,
Based on the First Amendment of the U.S. Constitution, a public figure cannot recover in a defamation case unless the plaintiff's defamation was done with actual malice.
That is true.
Yeah. So people in the public eye, including politicians, rock stars, movie stars, they don't have a right to privacy and also can be defamed. Okay. For some reason. Why can they be defamed? I don't remember why, but they can be. Where are we at? 7.3. Negligence. Okay. Blank is the breach of duty of due care.
Negligence.
You didn't sound too sure about that one, Kaylee.
I know.
Blank is an act of the defendant that violates a statute, regulation, or ordinance and can be used to establish a breach of duty of due care. Is this? It's an act of the defendant that violates a statute, regulation.
Oh, it's negligence per se.
Yeah, establishing a breach of the duty of due care where the defendant has violated a statute or municipal ordinances is eased considerably with the doctrine of negligence per se. Okay, great. The blank of negligence is sometimes called the but-for event that is a breach of duty on the part of the defendant.
Isn't that the proximate clause?
Proximate cause. The proximate cause
Oh,
of
it's the
negligence.
actual cause.
The actual cause. Proximate cause, actual cause. Any other voters?
I don't know this one. So
yeah, I think actual cause.
I think it's also actual cause, so we'll go with that. It's actual cause. So the actual cause is the but-for event that is a breach of duty on the part of the defendant. In tort cases, the rule of blank creates a presumption that the defendant was negligent because he or she was in exclusive control of the situation and that the plaintiff would not have suffered injury but for someone's negligence. This rule shifts the burden to the defendant to prove that he or she was not negligent.
I think it's the res liquidator.
Yeah, that one. However you
Yes.
say it.
Literally meaning the thing speaks for itself. So that might be useful to know in English. For some reason, they can't just tell us the English phrase. They have to give us Latin. The
The
thing
worst
speaks
part
for
of
itself.
law right there is that literally like they just use non-English, and you have to just like
Dude, I sit here
know what it
Googling
means.
so many words when I read the notes in the book.
Yeah, I've Googled all these phrases like several times.
Same. I'm like, why don't I know it?
Under the rule of blank negligence, the negligence of the plaintiff is weighed against the negligence. This is contributory negligence. I'm sorry, but you don't even have to read the whole thing. This
I think
sentence
it's
tells us.
comparative.
Ooh.
No, and with a defendant's negligence outweighed.
It could be comparative negligence.
Contributory is when actions of a plaintiff that contribute to his or her own injuries. And it's only used
Yeah,
in a few states, it says.
It's comparative.
Comparative negligence.
Mm-hmm.
Awesome. Cool. So blank is the breach of, oh, we already did this. Okay. 7.4. Strict liability. So a tornado damages a wall in Harold Baker's barn, and the cows and other livestock escape and damage neighboring property. Baker will be held liable for the damage under the principle of
Strict liability.
strict liability. The owner of animals that escape from their pastures or homes and damage neighboring property may be liable, even if the reason for their escape was beyond the power of the owner to stop. Okay. That's the only one for this. Great.
Easy.
Okay, that was torts, right? So is there a chapter on negligence? No, that's just a piece of torts. Okay, so
Chapter 20 is next, I think.
product liability? Yeah,
Mm-hmm.
great. So quiz. Blank is the legal theory imposing liability on a person for the proximate consequences of her carelessness. The legal theory imposing liability on a person for the proximate consequences of carelessness.
Assumption of risk? No. Negligence.
I kind of want to say
Yeah, I think
negligence.
it's negligence as well.
Yes, negligence, a tort theory, is the legal theory imposing liability on a person for the proximate consequences of her carelessness. Okay, in products liability cases, warranty is governed by the common law.
False.
Why?
It's governed by the UCC.
Oh, perfect. Contract theory, warranty is governed by UCC. Okay, you're excused. An express warranty is created whenever the seller affirms that the product will perform in a certain manner.
True.
True.
Express warranty, true. Created whenever the seller affirms that the product will perform. Okay, an express warranty is created. Didn't we just do this?
Yeah. D.
Yeah. D, yeah, I heard B for some reason, but a blank warranty is imposed by law and comes along with a product automatically.
Limited.
Implied?
Is it limited?
To be limited.
It's an implied
Ah,
warranty.
That's my bad.
An implied warranty is one that circumstances alone, not specific language, compel reading into the sale. In short, an implied warranty is one created by law. Okay. Jesse asked the store assistant for self-raising flour. The assistant hands him a bag of flour and he pays for it. Later, he realizes the flour he bought was plain flour and not self-rising flour. Which of the following types of warranty did the store assistant breach?
I think
Is
implied.
it the implied warranty of merchantability?
That would be my guess.
Implied warranty of fitness for a particular purpose.
So it's one of these three, eh?
Oh yeah, that one. The fitness for a particular purpose. Yeah,
Okay.
it's that one.
Yeah.
Whenever a seller, at the time she contracts to make a sale, knows or has reason to know that the buyer is relying on the seller's skill or judgment to select a product that is suitable for the particular purpose the buyer has in mind for the goods to be sold, there is an implied warranty that the goods are fit for that purpose. Okay, according to section 2-314 of the UCC, merchantable goods are those that
Always different. I think it's C.
merchantable goods are goods that pass without objection in the trade under the contract description. C. Okay.
And there's like 6 parts to that code, just so everyone knows. And that was one of them.
I just saw it. Is it this here?
Yes.
So it is in the PowerPoint. If you guys wanted to write this down on your note sheet, it might be
And
useful.
number 1 was the one that we put.
Great. Next question. The Magnuson-Moss Act does not apply to consumer products.
False.
What is the Magnuson-Moss Act?
It tells the consumer what to do if a product becomes defective or malfunctions.
Okay, the Magnuson-Moss Act only applies to consumer products. All right. Which of the following is true of the Magnuson-Moss Act? Okay, so right off the bat, I don't think it's E, because earlier it said it
I
has
don't
to be a
think it is
consumer
either.
product. So it's not E. Permits the seller to disclaim implied. So it sounds like we need to really know what the hell this is.
I think it's A.
A, does
I'm not
anyone have
sure.
any other guesses? A, yeah, Magnuson-Moss Act requires that the warranty be labeled under full or limited. Okay, blank is the relationship between two contracting parties.
Privity.
Privity is the relationship between two contracting parties. There's vertical privity and horizontal privity. Yeah. Doctrine of privity has held that one person can sue another only if they are in privity. Blank is the relationship between the original supplier of a product and the ultimate user or bystander affected by it. This is
That
going
one's
to be
horizontal.
horizontal privity.
Mm-hmm.
Yeah. Great. Dean, which of the following sets of contracting parties would there be vertical privity? I think it's wholesaler and buyer, but no.
I think it's
I think it's manufacturer, customer.
no, because that's customers and doesn't. Vertical is in between. I think.
See, my example I wrote down was like the relationship or whatever, the connection between manufacturer and retailer.
It's wholesaler and buyer.
Okay.
For whatever reason, I don't know. Vertical privity is privity between parties occupying adjoining levels in product distribution systems.
Oh, I think it's because it says wholesaler, and wholesalers typically don't sell to consumers, and so it's implying that the buyer is the seller of the good.
Yeah.
I
So
think.
let's see here. There's like a diagram. Where is this diagram? Here's the diagram. Okay. So wholesaler and retailer are vertical. Okay. Question 10, between which of the following sets of contracting parties would there be vertical privity? Oh, we already said wholesaler and buyer. Okay. So which section was that in? 22, here's 20.3. Privity is never relevant for a case of negligence. True or false?
I don't know, but I'm gonna guess false.
I think that's
I would
false.
say it's false because I mean, even if you're in like partnership, I guess like you could still fuck over your partner.
Negligence is a tort
Really?
theory as compared to a breach of warranty, which is of course a contract theory. And it does have this advantage over warranty theory. Privity is never relevant in tort theory. Yeah.
But we all missed that one. Or a majority.
Okay, blank is a theory that a federal law supersedes any inconsistent state law or regulation. Impracticability. What is this word for? I don't understand it. Preemption, yeah. Seems like it's out of a different section. Okay, 20.4, strict liability. Which of the following is true of strict liability under the section 402A of the Statement of Torts? The customer must give the seller notice of injuries within a reasonable time. Privity is a mandatory requirement for a user to prove strict liability. Limitations and exclusions and warranties apply to a suit based on restatement theory. No proof of negligence is required for strict liability under the restatement, or the formulation for strict liability covers both physical harm and economic loss.
I think it's either D or E, I would think, right? No, do you think A?
I think A, yeah. The customer must give the seller notice of injuries within a reasonable time. If you like experience a defective, like use of a defective product and then wait like 10 years to tell them, it doesn't matter.
Yeah, I guess it would depend because it's saying specifically under section 402A, but like D and E could also be true, I feel like, because it is economic and physical harm.
True. So did you say D?
No, I'm not saying those are the right because I don't know what 402A is, but I'm saying like in the example of like the cows getting out because of a hurricane or a tornado or whatever, that would imply both economic and physical harm to whoever's property they damage, correct?
I think so, yeah. So which answer should we go with, guys?
I agree with him on E, physical and economic loss. Oh.
All right.
Okay. No proof of negligence is required for strict liability under the restatement.
Yeah, because that's like it specifically said when we read about it that it doesn't necessarily mean that whoever, like, again, to go back to the example of the cows, the owner didn't have to be negligent for the cows to get out. That's like the example I would think of.
All right, on to the next. The formulation of strict liability under section 402A of the restatement is limited to the blank suffered by the user. This economic loss, psychological damage, damage to property, physical injury, or loss of credibility.
all seem right to me, so I have no idea.
Right.
I'm gonna guess A. Does anyone want to support me or reject that yes?
I say send it.
It's D. Okay. The formulation of strict liability under Section 402A of the restatement is limited to the physical injury suffered by the user. Okay. So formulation of strict liability is limited to physical harm. If the product has been altered, losses caused by injury are not the manufacturer's liability. True or false?
I would say true.
True. That's one of the main defenses to manufacturer liability is product alteration. Blank is a liability without proof of negligence and without privity.
Wouldn't it be strict product liability?
Yeah. Yeah.
Yes. Great. 20.5 tort reform. Okay. A blank is a statute limiting the time that a product manufacturer can be liable for the product's defects. This is
Statute of limitations.
limitations. Yeah. No, statute of repose.
What?
Statute of limitations is not about products.
Oh, yeah. Oh.
I think a statute of limitations is like in criminal
For
law,
crime.
maybe. Yeah.
Yeah.
A statute of repose
Compensatory.
establishes time period, generally ranging from 6 to 12 years. Okay. In states that have enacted comparative fault statutes, the damages a user receives for a manufacturer's negligence depends on the degree of
I think D.
the percentage of responsibility for the injury that the manufacturer bears. And that has to do with what did they call it? Comparative negligence or
Yeah.
okay,
Or contributory.
contributory negligence. Okay.
But
So
this is comparative.
Okay. All right, 20.6 is cases, so we're on to what now?
Intellectual property.
Intellectual property. Okay. What chapter is that?
32.
Okay. If the patent of a design, if the patent is a design patent, the patent is valid for a period of 14 years.
True.
Design patents are good for 14 years. Okay. According to the patent law, the means devised for the production of a given result is termed as is it a process? I think it's process.
I agree.
Yeah, process. Which of the following can be patented? Hybrid plants, processes, minerals, gravity, algorithms.
Hybrid plants. Or can processes
is that-
too?
Wait, are you serious?
No,
Processes
it's not
can
hybrid
be.
plants because it's processes.
Even if it's like a new gene sequence or whatever?
Yeah, because technically it could still happen in nature, I think. And so
Okay.
that's a
What
natural
about
phenomenon.
Monsanto? Don't they like patent their seeds?
I have no idea.
With regard to the patent law, which of the following is excluded from receiving patent rights?
It's an algorithm. Well, I understand why that's correct, but like, how does that make genetically modified potatoes not?
Right.
I guess
was
if it's
thinking the same thing.
like looking at the last question, I guess if it's a hybrid plant, that's technically just a combination of two, but a genetically modified potato is going to be like someone had to do something to make it genetically modified.
Yeah, right. A hybrid plant, you can have like you could like take an apple tree and cut it and splice it to a pear tree and then have a
Yeah.
hybrid plant.
Well, I heard you can't put a patent on food. So I don't know if that's true or not.
The doctrine, yeah, maybe we'll have to do some more, take a look at this chapter
As
on
far as like
patents.
the food and like the plants go, I would say like maybe a reason you can't put a patent on them is because you can't exactly replicate it perfectly.
Well, this last question told us we could patent a GMO potato. So,
I think it has to do with the composition of matter one, like a rearranging the elements so it's not found in nature.
And I guess that technically a hybrid plant could be found in nature.
yeah,
Yeah.
okay, yep. Composition of matter makes sense to me. Okay, number 5, the doctrine of equivalence with regards to patent rights states that, what the hell is the doctrine of equivalence and what does it state?
Doctrine of equivalence is a judicial doctrine that infringing products, processes, or machines need not be identical.
There you go. Doctrine of equivalence states that infringing products, processes, or machines need not be identical. Okay, so what does that mean?
So like if I made like this hydro flask and I made it just a little bit different, like just this lip was different, it's pretty much exactly the same. And so it would be infringing on the patent.
Okay. Okay.
So it doesn't need to be like the exact product. It just has to be like similar enough.
It's kind of like how a few years ago, I think Samsung was suing Apple for like creating some similar technology to them or something like that. Makes sense though.
Apple gets sued all the time for that.
Your explanation made perfect sense. So basically, if it's slightly different, you can still be like breaking the patent protection. Okay. Now on to 332.2, trade secrets. A blank is a process, chemical formula, list, plan, or mechanism known only to an employer and those employees who need to know it in order to use in the business.
Trade secret.
Trade secret. Trade
What is
secret.
a trade secret for 500?
A trade secret gives its owner the right to enjoin anyone who infringes it from making use of it.
I think true.
True. A trade secret.
Yeah.
What does enjoin mean?
To prohibit someone from performing a particular action by issuing an injunction. I had to look that
It's
up.
false. So a trade secret gives its owner the right to sue only the person who improperly took or revealed it.
Yeah.
Okay. So it was false.
Oh, okay.
Yeah, so if you have a trade secret and you give it out to your employees and then they want to go and make a new business, is this saying like they could just steal your trade secrets?
I think they're talking like
but
Neiman Marcus. Neiman Marcus used to make cookies, and then somebody tried to back engineer the formula for the cookies and then put it out there. You and I can make the cookie without being sued, but the person who back engineered would be responsible.
Oh, okay. That makes a lot of sense. Good explanation. The blank makes the theft or misappropriation of a trade secret a federal crime.
I believe it's the Foreign Corrupt Practices Act. Or is it that one? Or is it this?
Oh no, it's the Electronic Espionage Act.
You mean
Or
the
economic. Can't read my handwriting.
Yeah, the Economic Espionage Act, yeah.
Yep, of 1996
Foreign
makes
drug
the
prices
theft or
up.
misappropriation of a trade secret federal crime. So like you said, Rick, the guy who stole the recipe committed a crime, but you and me, as receiving the trade secrets, we can use them now. Yeah. Okay. An agreement not to disclose particular trade secrets learned or developed on the job is known as,
A non-disclosure agreement.
but we don't
Or
have that.
I guess a confidentiality agreement. Yeah.
Yeah.
100%. A blank is a process, chemical formula. Oh, we already did this. Okay. Copyright protects the expression of ideas in some tangible form, but it does not protect the ideas themselves. I think this is true.
That is true.
Mm-hmm.
Yeah. Copyright is legal protection given to authors for their writings. It protects ideas in fixed, tangible form, not the ideas themselves. Okay, blank states that the use of copyrighted material in criticism, comment, news reporting, teaching, including multiple copies for classroom use, scholarship, or research that does not significantly reduce the market for the copyrighted material is not infringement of copyright. This is the fair use doctrine. Fair use. Okay. I can make a PowerPoint out of this textbook and send it all to you guys, and I won't get sued. Okay. Which of the following is true of a copyright?
I think B.
Yeah.
Mm-hmm.
Which among the following is eligible for copyright protection? Plays.
Plays.
Names, titles, symbols, and slogans, those are all trademarks.
Yeah.
Okay. In the absence of a copyright notice, a copyright holder loses the right to receive statutory damages if someone infringes the work.
I believe that's false.
False? What's a copyright
Yeah,
notice?
It's like when someone
because
says, it's like when someone says, "Hey, you stole my content here. You copied it, like on YouTube. Someone will send a DMCA, takedown notice to YouTube saying, "Hey, this person stole my content. Here's the proof."
Okay, so just because we haven't sent a copyright notice doesn't mean that we lose our right to receive statutory damages. So false.
Yeah.
It's true. We actually need a copyright notice. Yep. In the absence of a notice, the holder loses right to receive statutory damages. So, for instance, if I make music and I put it on YouTube and I don't in the comment section say, you can use this so long as you credit me, if I don't say that, if there's no notice of copyright, well, then I've lost my right to statutory damages if somebody does take that, because I have to tell them, hey, you can't just use this without crediting me.
That's not it.
No?
No, that's not a copyright notice. You're just you're not giving people the right to use it without crediting you, right? But a copyright notice is sending a thing to someone saying, "Hey, you stole my work." That's the copyright notice.
Okay, and so you don't have to do that in order to have statutory damages. Okay, which of the following statements is true with regard to obtaining copyright? Any guesses? This one's a tough one.
It's D.
I think C.
Okay, I heard D. I heard C.
I think it's D.
I think C.
I heard another C. So we'll sit.
All right, I guess I'm
it was
outvoted.
D.
No, D.
Hey!
The holder of copyright does not have immunity from an infringement suit. Okay.
Yep.
Just because you hold a copyright doesn't mean you can't be sued for infringement.
Because basically it's saying you could write a whole book But if, a chapter of your book is a ripoff of someone else's book, but the rest of your book is original, you can still get sued, even though you own the copyright for the rest of the book.
Yeah.
That makes sense.
So like, does that apply to like fan fiction? Like if I write fan fiction about like some copyrighted subject, am I liable for like copyright infringement?
So it's my understanding that technically you would be, but authors don't ever go after those people because those people aren't making any money off of it, at least in most cases.
Okay.
So most people are only concerned with copyright if the other person that's stolen their copyright is making money off of it. Because then they can get money from that person, after they unlawfully use their copyright sort of thing. Fan fiction's kind of a gray area. There might be a fair use reason, but you kind of have to look into the case.
Okay, guys. We're getting to about 8:45 now. And I do want to end this at 9. You guys are welcome to continue, but I'll have to leave then. So we can keep doing intellectual property, or we can move to criminal law, or we could cover something else before I head out. Up to you guys.
Maybe some of the essay stuff.
Well, it looks like we can.
Okay, I heard one person suggest essay. I heard Matthew. What were you saying, Matthew?
I was just saying we could just finish intellectual property. This is the last one, right? The last little quiz.
Oh, it is, huh? Okay. Yeah, there are only 5 questions as well. As far as essays go, I believe, Rick, you were the one asking about that? Okay, so as far as essays go, the session that I led on Sunday, we actually hit essays pretty heavy. So I would go watch that video, and we go over torts, we go over contracts, we go over criminal law, we go over administrative agencies, I believe, and we break down like how to respond to essay questions there, and as well as that review video that the professor sent out today. He explicitly goes over just essays during that video. So.
Oh, okay. Yeah, I haven't had a chance to look at that yet.
No worries, bro. So yeah, we'll I think I'm gonna just go with Matthew's idea. Finish up this free response or this multiple choice, and then we'll see where we're at. So let's see. A blank is defined in the Federal Lanham Act of 1946 as any word, name, symbol, or device, or any combination thereof, adopted and used by a manufacturer or merchant to identify his good and distinguish them from goods manufactured or sold by others.
A trademark.
I think it's a brand, but I'll put trademark.
Yeah, I think it's trademark.
Trademark, yeah, great. Awesome. A blank mark is used on many products to certify regional or other origin, material, mode of manufacture, quality, accuracy, or other characteristics such as goods or services, or that the work or labor on the goods or services was performed by members of a union or other organization. So this is a what mark? A quality mark, certification mark, standard mark, service mark, collective mark.
Certification.
Certification.
Okay, certification mark. Under the Trademark Law Revision Act of 1988, which of the following is true with regard to acquiring trademark rights? If the product was sold in interstate commerce, the trademark was entitled to protection under the common law of the state it was manufactured in. Once obtained, if after a stipulated period of protection the mark is still being used, the registration cannot be renewed. The manufacturer or distributor actually must have placed the mark on its product and then have begun selling the product before applying for trademarks. Once obtained, the trademark will be protected for 20 years. Trademarks can be obtained in advance by registering with the PTO in an intention to use the mark within 6 months.
I think D.
I think it's the last one, but don't quote me.
Okay, we got 1 vote D, 1 vote E.
I think it's the last one also.
2 votes E.
All right.
Going with E. All right, it's E.
Hey, got it.
Under the Trademark Law Revision Act of 1988, which went into effect in 1989, trademarks can be obtained in advance by registering with the PTO an intention to use the mark within 6 months. The applicant can gain extensions of up to 30 more months to put the mark into use. Okay, which of the following is true of loss of trademark rights? A descriptive term used alongside a trademark will result in the marks becoming generic. If a patent or copyright on which the mark is based expires, trademark owners will not lose their rights. Putting the words trademark, registered trademark, or the symbol R next to the mark itself does not protect the trademark from becoming generic. Trademark owners may lose their rights if they abandon the mark. Trademark owners will not lose their rights if the mark becomes generic.
I want to say D.
Yeah, I think it's D too.
Yep. Great. So last question, trademark holders cannot protect themselves from their marks becoming generic.
This is false.
Okay, it's false, you say, Eric? So how do
Yeah.
they protect themselves from becoming generic?
It lists 3 ways. You can use a descriptive term along with the trademark. You can protest generic use of the mark.
Yep.
And then make sure you always put the words trademark, registered trademark, or the symbol R thing next to the mark itself.
Okay.
Yeah.
Great.
I know Google is having this problem. Google's worried about their mark becoming generic because people say, oh, just Google it, right? And that's something that'll lead to Google becoming a generic term, as, you know, instead of saying look it up, it's going to be Google it, right? And Google's worried that they'll lose their trademark on Google, which is kind of funny.
Okay, can use a descriptive term along with trademark, protest generic use of mark in all publications by writing letters. And so, like, are you saying Google is their only option is to do this? They have to protest the use of generic use?
Yeah, Google's already protested the use of it generically. They don't want people to do that.
Interesting.
Oh, well, the whole world does.
I know, it's a bit late. It's a bit late for Google.
Right.
Okay, so what we left to cover is criminal law and contracts and bankruptcy secured transactions. Okay, I would stay longer, but I honestly can't. I have a lot of stuff to do, and I still have to write my my outline. So, is anyone finished with their cheat sheet for the exam?
No.
I have to finish my outlines and my cheat sheet tomorrow.
Finishing outlines and cheat sheet tomorrow. Yeah, I'm in the same boat.
So what's your guys' best way of going and like studying? I know that kind of sounds stupid, but like, are you guys just going through each chapter and like reading, or are you guys kind of just?
Sorry, each chapter has a study button up at the top right. You click it and it just gives you the key points of every chapter.
Okay, cool.
That's like what I do for like quicker review. Yeah.
I have PTSD of that, man, because I feel like I just took a midterm for another class and I did that same thing. And literally everything that I wrote down on my cheat sheet was from the study like tab like that, and nothing on my cheat sheet was on the set.
So he said the midterm review is pretty much everything we need for the essays.
Okay.
And then it'll cover about 60% of the multiple choice is what he said this morning in the review, based off of the review sheet he gave us, which he also went over in the review, which is what Connor did at the beginning of this. And then other than that, it's coming from the book and the lectures.
Yeah.
Okay.
I did notes on all the chapters. I'm just reviewing like my notes to make my outlines, and then I'm just using like the study guide and probably the PowerPoint that Connor made last time.
I think the outline is due tonight, isn't it?
No, it's due the day of the
Thursday
exam.
morning.
Oh, okay. Okay.
Yeah.
Yeah,
Before you take the
I
exam.
don't want to waste my time studying on stuff that like isn't even going to be used.
What I would recommend, Robert, is go watch that review video that he posted this morning.
Okay.
I already outlined it for you. I took detailed notes and I outlined it for you guys today. This is exactly what he talks about. But you need to know all of this stuff for the essays. And then for the multiple choice portion, it can be anything from any of the sections that we've read. So definitions, case rulings, mostly definition based, some application based multiple choice. As far as that
Are
goes,
we gonna have case ruling questions about from the chapters?
I'm not sure. He didn't say that there would be cases, but I think I would just rewatch that video because I didn't catch everything. I think he said something about that. I'm not 100%
He
on
sent
it.
he sent us that review video.
Yeah, it's gonna be in the media gallery.
Oh, okay, cool.
Yeah.
Yeah.
As far as that goes, if you have the link that I sent out, in
Yeah,
the
I
chat,
starred your midterm stuff in my Google Drive.
This study guide. So I forget who gave us this on Sunday. They gave us this. Their friend took this class last semester, and this study guide here is basically the same study guide he gave us, except it's filled out.
Oh shit. Okay.
Some of it has changed because they use a different textbook, just so you know. Like those functions of law has 8 on this one, but our book only has 6.
Yeah, okay.
Yeah.
Functions of
But
law.
a lot of
that's
it
okay.
is the same.
Okay.
Yeah, so
Just
you
be
can
careful of some of the little things.
Yeah, and also this study guide, like, it's still gonna help you mostly with essay questions. Multiple choice are gonna be drawn, I think, mostly definition based out of the book. So
I feel like the multiple choice though, you can at least if it's 4 or 5 choices, at least you can kind of just narrow it down and then kind of just use your best judgment.
I think the multiple choice are going to be pretty much identical to what we just did.
Yeah, exactly. That's kind of
Yeah.
I would hope. Let's pray. I don't know. This has been kind
What
of
what I'm doing is I'm gonna put like the whole like review session from today for like the essay questions on my note sheet and try to have that pretty much like, I mean, obviously know some stuff about it, like, and not super detailed, but like have that basically filled out and then fit as many definitions and stuff that I'm not really too sure about for the note sheet. And then for studying like textbook wise, I'd mostly just focus on like terms. I think that's what it's going to mostly be.
Yeah, I think that it's going to be. Yeah, I agree. Let's hope. Yeah, I just get nervous of wasting time on like, okay, this is what's going to be on it, or what I think, and then having nothing on my note sheet.
What are you guys doing first? Multiple choice or essay?
Yeah, so
I think if essays are worth more, I'm probably going to do essays because
well, they're each worth 50 points.
I heard that you should do the multiple choice first, but make sure that you're only using like 30 to 60 seconds per question so that you get it out of the way so you have more time on the essay. Because
I did see in the group me though that they were only getting 75 minutes prior, and now we're getting 2 hours. So I feel like we have a
So yeah, we're not on the time constraint as much, and we're given the same amount of stuff to answer. But
I would say if you start with the essays first, just make sure that you're like watching the clock and not going to run out of time, because if you spend like an hour and a half on the essays and then you go into the multiple choice and you don't finish, like, good luck. You're going to answer C on everything. But
I mean, I heard to do the essay questions first, just because if you end up taking too long on the multiple choice, there's no way that you're going to get any points. Pretty much.
I'm pretty sure that's what he told us to do.
Yeah, and then that way, if you start on the essay questions and you run out of time, you can still guess and hopefully get some points.
Yeah.
Yeah, 100%.
Have a good night, everyone.
Thank you for hosting this.
Oh, thank you guys for showing up. I'm going to drop this midterm review in the Google Drive folder as well, so this will be available there for you guys.
Thank you.
All right.
Good night, guys.
Thank you.
Thanks, guys.
Later.